Welcome to tonight's Law Talk webinar, Freedom of Association, Your Rights as an Educator in Tennessee. I'm Samantha Bates, Director of Member Services. My background is in middle school education. I taught for 5 years. I was a grade level leader, club sponsor. I joined Professional Educators of Tennessee in 2008 as a student member, upgraded to a professional member, and got my 50% off my first year. I've been a treasurer of the board of directors, and I've been in my current role at the main office for 1 year on Tuesday. So I joke that I've been at every level except retired. So you would think that my history with the organization and this topic, that this presentation tonight is going to be like an infomercial or promotional materials, but that's not the purpose tonight. We're just going to discuss the laws regarding your rights and some statistics, as well as some choices you have as a U.S. citizen and an employee in Tennessee. Also, fun fact, we're not a union. So if you have any questions during the webinar, you can use the questions pane, and I will answer those as they come up. There's also a way you can raise your hand. Please don't do that because I won't know your question and I can't answer your question. This webinar is being recorded, so if there's anything that you want to go back and watch or anything you want to share, it will be uploaded to YouTube, like all of our other Law Talk webinars and professional development conference sessions that we have. That is at youtube.com/proedtn. Don't go there right now because you want to finish the webinar. If you read any articles on right to work, you will see that it's a very controversial topic, and it is, if you just went by the articles and the rhetoric alone, you might conclude that right to work is very complex, it's multifaceted, and you might end up confused, but right to work laws are actually pretty simple and straightforward. No person can be compelled as a condition of employment to join or not join, or to pay dues or not pay dues to a labor union. That's it. That's what right to work is. For some, it's viewed as an anti-discrimination law, since union membership decisions are often made based on religious and political beliefs. And so if you read it that way, you could say that even if your religious beliefs cause you to join or not join, you can't be discriminated against. You can't be hired or fired because of that. A lot of people view it as anti-union legislation, but really it's about personal freedom. Nobody can argue that unions historically have not done great things for the United States. I mean, no one's a fan of child labor. They set the standard work week, living wages, and they increased safety in the workplace. So it's not about unionism itself. It's about freedom and your right to choose. It's not a Southern concept, which is another misconception. Half of U.S. states have right-to-work legislation, including Wisconsin and Michigan, and those are definitely not Southern states. It's also a current issue. Right-to-work laws have been implemented since 1947, but the most recent would be Wisconsin this year. And I think Illinois right-to-work legislation was just defeated, and Missouri state legislators have just passed right-to-work legislation, but I think Governor Nixon is going to veto that. I don't live there and I don't work there, so it really doesn't apply, but I just want to emphasize that this is a current topic, and even if our laws in Tennessee are old, it is a current and controversial topic. So you would think with right-to-work legislation being so controversial that statistics would show a huge divide in the country, but you might be surprised to learn that only 11% of Americans are union members, and that number is dropping. 5% of Tennesseans are union members, and as far as education goes, nationally, 35% of education professionals are members of unions, and in the private sector nationally, about 12% of educational professionals are members of unions. So public school educators are more likely to be union members, but it's still not a majority. So I found that highly interesting, considering how controversial right-to-work laws seem to be. So let's look at some laws and rights that you have. Federal law guarantees employees' rights to join, form, or assist unions, or to not do any of those things. If you work in a right-to-work state, union membership and payment can be completely optional. So if you work in Tennessee but you live in Kentucky, which is not a right-to-work state, because where you work is where the employment laws related to your job are, that's where it's optional for you. In non-right-to-work states, union membership is optional, but payment is mandatory, and that's related to exclusivity and bargaining and paying your fair share. We're not really going to get into that because that does not apply to our state, but if you talk to someone about unionism that's from another state, the conversation can go all kinds of ways, and I just want to give you a heads up on that. So that's federal law. These are laws specific to Tennessee. There are only 3, so if you do a right-to-work law search in Tennessee, possibly more than 3 laws will pop up, but these are actually our right-to-work laws. They're very basic, and they just say that to be employed, your employment cannot be contingent upon whether you are a member or non-member of a union, or whether you pay dues or you don't pay dues. And these have been on the books since 1947. So this is not new in Tennessee by any stretch of the imagination. And I said that if you search for right-to-work laws, you might see more than those 3. PECA, the Professional Educators Collaborative Conferencing Act, and also there's an equal access law for domestic professional educator organizations like us that relate to student teachers and people in teacher training programs in the state. Those really deal with exclusivity and not really right to work. But exclusivity is related to unionism because bargaining typically relates to one group representing employees and one group representing management coming together and discussing. But in Tennessee, there are laws that prevent forced exclusivity. And it's interesting, in 1936, the Supreme Court ruled that a new law that had passed regarding mandatory collective bargaining and exclusivity to be, quote, intolerable and unconstitutional. It said that to accept in these circumstances is not to exercise choice, but to surrender to force. In effect, in respect to wages and hours, it is to subject the dissenting minority to the will of the stated majority. And so a statute that confers such power over an unwilling minority is intolerable and is an unconstitutional interference with personal liberty and private property. So these laws aren't actually right-to-work laws, but they are related in that they strengthen educators' choices and give additional rights both to union members and non-members. A few of the additional rights that these laws confer have to do with communicating to coworkers, distributing and posting information, and recruiting. In the past, we would frequently hear things like, well, I'll ask permission if I can put this in a mailbox, or I'll ask if I can post this. State law now says that you don't have to have permission, but there are some guidelines like before and after the instructional day as far as accessing other teachers. And, that to us is just professional courtesy. But like I said, these are your rights. So looking at your rights, let's look at how to exercise them. Federal law guarantees your right to join or form or assist or not. And union membership and payment here in Tennessee is optional. So if you wanted to opt out, we're going to go over some ways to do that in the following slides. I frequently get questions from educators about how to leave a union. I would love to give a simple answer that was very direct and specific, but the answer is, well, it depends. Unionism is really contextual, and when and how to opt out is related to federal law, but also bylaws and membership forms that you may have signed. There are some legal guidelines and there are some organizational guidelines to opting out. And also, when you join a union, you have two contracts, essentially. One is membership and one is payment. And that's why when you saw the state laws, one said you can be a member or not, and one said you can pay dues or not. That seems kind of odd because in our minds, when you join something and you pay, that's one decision, but it's actually two separate. And that also has to do with the way federal laws and right-to-work laws work. So legally, under federal law, you have the right to resign without coercion or restraint, and there are many, many, many court cases that support your right to resign from a union. Now, organizationally, though, there may be some guidelines that you are subject to, or at least are told you are subject to, and those relate to how to pay, how to resign, and the timing of the membership period, and how to terminate membership. And these may or may not be legal. For example, frequently union bylaws have like a time period to opt out. This is normally between May and August for an upcoming school year. I think the most limited that I have seen says from August 1st to August 31st. They also will have provisions about to whom your letter of resignation should be addressed, and that's another stipulation that it has to be a letter. Usually it's the local president and the payroll department or business office because, like I said, there's the membership and then there's the payment. And so those are the two different heads of that. And then they can also stipulate a specific method to resign. For instance, one that you're actually going to see maybe requires an original signature, which means that you couldn't fax or email a resignation to the president. You would have to actually mail them a letter or hand deliver it. So how do these bylaws relate to federal law and your right to resign? As recently as last year, courts have ruled that resignation time windows are illegal even if they're included in the bylaws. Resignations cannot be refused or restricted or conditional. Courts have upheld that resignations may be submitted in multiple ways. One court case involved a member ripping up a union card in front of a local president. I think that one's a little bit extreme, but the court did rule that that was sufficient notice. We would always suggest doing anything important in writing, mostly so there is documentation that it exists. You should also know that your rights can be exercised at any time. And the only thing that would prevent any of these stipulations and any of these legal precedents from applying would be you waiving your rights. And to waive your rights, you have to know about your rights and you have to agree to waive your rights. The best example that I can give is any law show you will see someone getting arrested and being read their Miranda rights, or really being, I don't think any cop doesn't have that memorized, but you'll hear the Miranda rights. You know, you have the right to remain silent. You have the right to an attorney. Well, if you don't know that you have the right to remain silent and you don't know that you have the right to an attorney, you can't waive that right. And that's really what the Miranda case was. You can't waive rights you don't know you have, and you have to knowingly waive them. So let's look at what informed consent really looks like. Ignorance is not a waiver of rights. I have not shrunk these at all. These are the actual size of the resignation provisions on a membership form in Tennessee. I've blurred out where it is and what exactly we're talking about, but this is the size. It is, I'm guessing, a 4-point font. In 1973, a court ruled that there had to be evidence that a union member knew of or consented to limitations on right to resign for those limitations to be in effect. I'm guessing this may count as knowing. If you only see this one time when you first join, that may or may not count. But last year in Michigan, courts ruled that bylaws alone are not sufficient for consent. You you can't waive a right that you don't know is waived because you didn't go searching through 30-year-old bylaws. But these say that by signing below, you agree to remain a member of this group, and you may cancel your membership for an upcoming year, a subsequent year, by sending a signed and dated written request to them prior to June 1st, and you agree that only an original signature is accepted, not facsimiles or emails. And then down at the bottom, I hereby authorize my employer to deduct from my paycheck annual dues for this group and political action contributions as indicated. My membership authorization will continue until revoked in writing to the president in accordance with the continuing member provision noted above, and I agree to hold the board harmless for these deductions, and any conflicting provisions of this form are governed by the bylaws. So you'll see it says I agree in, I think, 3 or 4 places. That's informed consent. They are informing you, and you are agreeing to these provisions. And you notice it says for a subsequent year, an upcoming year. Frequently we get questions about mid-year changes, and that really brings up a question about dues. Federal law says that you can resign your membership at any time, but like I said, membership and payment are separate. Some states have provisions in their right-to-work laws for this question. Like Michigan, their state law says that when you decide not to be a member, you never have to pay dues ever again. Tennessee state law doesn't say that. It just says you can't be fired for not, or you can't be hired for not, the other way. I'm not aware of any litigation in Tennessee over union dues, but you do need to understand that dues deduction authorizations are a contract, and so that might be governed by contract law. So the implication with these laws and your rights is that educators have a choice, and all laws are written both ways. So the laws themselves do not encourage or discourage union membership, but you do have a choice. If you wanted to join a group, there are professional associations. If you wanted to not join anybody, you could be unaffiliated. Now, I mentioned at the beginning that professional educators is not a union, so the question I always get after saying that is, so what are you? We're an association. And then the next question is, well, what's the difference? 501c6 organizations, it's a designation in the tax code, and I'm going to explain that because it's a big deal and it has a lot of different criteria, so it doesn't really mean anything to the average person. We're also nonpartisan. Unions are traditionally aligned with the Democratic Party. We're not aligned with any party. Association membership is volitional. You have a choice and you have the freedom to associate. We are professionally respectful. That is how we conduct our business. And we are member-driven, which describes how our policies are set. So when I answer questions with, well, we're a 50c6 and unions are a 50c5, that doesn't really mean anything to most people, but it actually covers a lot of ground. There are 7 criteria to being a 501c6, the first of which is a common professional interest of the members. So a common job or trade or industry, a common goal, but it has to relate to the profession. The purpose of a 501c6 is to promote the common interest stated above. 501c6 organizations must have meaningful member financial support. Meaningful is not defined anywhere in statute or in tax code, but for us, our membership dues are 100% of our funding. I love hearing rumors about how we get our money. The answer to that question is our members, the educators in Tennessee. That is how we get our money. That is how we are funded. We are not for profit, so it is not a commercial activity. The activities of the organization must be directed to improve professional conditions. I'll frequently say when someone asks about are we a union, I'll say, well, we do the same things but in a different way. So if you take that one at its face, unions exist to improve professional conditions. Associations exist to improve professional conditions. We just do it differently. Associations cannot perform services for individuals as the primary function. And The purpose of a 501c6 cannot be to engage in a regular business that normally someone would make a profit off of. So we can't sell things and say, well, we're an association for selling this product. That's not how it works. So that's our purpose and our funding. So frequently we're asked why our dues are so low. Our dues are $179 a month. That is, depending on where you are in the state, up to a third of the cost of being a union member. One way we can save a lot of money is by being nonpartisan. Political campaigns cost a lot of money, and so when you don't contribute money to politicians and parties and political action committees, you save a lot of money. We are not a political action committee. We do not have a PAC. We do not promote or endorse specific political candidates or political parties. We do not advocate for or against legislation or policies unrelated to education. And we don't accept money from political groups. Like I said, we are funded by our members. So this always leads to the question, so how do you advocate for educators if you don't do any of these things? Well, we work with politicians of all political parties to enhance the teaching profession, because that's our purpose, to enhance the teaching profession. We monitor and inform our members of education, legislation, and policy changes. In fact, we have a great legislative advocacy opportunity coming up in July and August. So if you're interested in the topics of updated No Child Left Behind legislation, or BEP funding, or Shelby County Schools, or testing, or PE, or attendance and truancy, you should email advocacy@proedtn.org about that opportunity. We do collaborate with other statewide organizations to promote educators as professionals and to promote the education profession. You're going to see a trend here. This is what we do. And we do represent the views of our members to politicians respectfully. Obviously, if we go to such lengths to be nonpartisan and collaborative, we have to respect others' ideas and opinions and their choices, and respect educators as individuals. Membership with associations are voluntary, completely voluntary. Membership with a local, state, or national organization is not necessarily a condition of membership with us. So we don't have local chapters without our members' desire and consent. And because we don't have a national, we set our own policies. Our members do. We don't answer to a group in Washington. We've talked about respecting our members, but also we respect the education profession. We don't believe in teacher strikes, walkouts, stickouts, or picketing, as we believe it hurts children, which kind of works out because striking is illegal in this state anyway. We don't promote or engage in militant, adversarial, or unprofessional confrontations. Our goal is collaboration, and that only comes with mutual respect. We strive to earn and keep the respect of our members and the respect of other organizations. We do not view education as us versus them, or employee versus management, or teacher versus student, or administrator versus the staff, or the superintendent versus all the administrators. Our members are teachers. They're assistants. They're administrators. They're coaches. They're secretaries. They're superintendents. They're custodians. They're state policymakers. They're parents. They're substitutes. They're college students. They're retired teachers. You can't pit groups against each other and expect to succeed. We have members at every level. Our common professional interest is educating children, and you have to be on the same team to do that. So I just described how diverse our group is, and now I'm about to tell you how we're member-driven, which is an interesting concept. When you put the two together, our members primarily are administrators and teachers. We don't have divisions or committees or caucuses, but we do survey and communicate with our members directly. Our policies are not determined by our staff here or bought by outside interest groups. We listen to every educator who wants to be heard. If you have questions, concerns, or opinions, you can visit our website for more information at www.proedtn.org. If you have questions for me specifically, especially about this presentation, because it was a lot of information, And I probably talk too fast because that's just what I do. My email address is samantha.bates@proedtn.org. If you need legal assistance, our general counsel can be reached at legal@proedtn.org. If you have an idea or a question that could become a Law Talk webinar, you can also submit that to legal@proedtn.org. You can actually see us in person live by attending the Law Talk sessions at Leader U, our annual conference. It will be held on June 20th in Franklin, Tennessee, and I would encourage you to come to the reception the night before on the 19th, because that's just me. The food was outstanding last year. If you want more information on Leader U, visit www.leaderutn.com for more information. This webinar and others, including past law talks and other professional learning topics, can be found on our YouTube channel that I discussed at the beginning, but I'll share it with you now, youtube.com/proedtn. And finally, you can join our professional development email list and receive information on upcoming webinars and other learning opportunities. You can contact our Director of Professional Learning, Bethany Bowman, at learning@leaderutn.com. There are no questions that I can see, so thank you and have a great evening.